fifth principle that he identified. One of the functions of a building is to provide shelter and security. He did not say that that was the only function of a building. And the FTT was quite right in my submission at 109 of its decision to say that a function of a building could include securely containing people or things. What we also saw this morning was that what the FTT did was to take into account both characteristics and function. I illustrated that by reference to the CHF cylinder handling facility and also uranium oxide store. And I do say, in the light of that approach that the FTT took, of looking both at characteristics and also function, none of the criticisms that are made of it in paragraph 131 of the upper tribunal decision hold water. Can I just take those in turn? They're at bundle page 179 to 180. First of all, there was a criticism that the FTT had, the UT said, failed to acknowledge or discuss the various potential everyday meanings of the term building and to consider which might best accord with the purpose of construction of section 21. I don't accept that as a characterization of what the FTT decided. It considered the scope of the term building in paragraphs 103 to 110 of its decision. It was entitled, I say, to conclude that it should look both at function and also characteristics. And the weight to be given to each of those matters is classically a matter of fact or a matter of evaluative judgment. So that, I say, can't give rise to an error of law. The second criticism was that the UT held that in placing emphasis on the physical appearance or characteristics, it said that it had failed to guard against certain pitfalls which it had set out in paragraph 125, and in particular that the FTT had focused on appearance or characteristics rather than on function, was how it was put. That doesn't amount to an error of law either, because really that's a complaint about weight. I don't accept in particular that the FTT focused on characteristics rather than on function. On any fair reading of paras 111 and following, it looked at both. How much weight to give to those aspects was a matter for it. And then the third complaint at 131 was that the FTT was said to have placed weight not on what it has found as a fact to be the predominant functions of those facilities, but instead on actual or potential functions which it considered were consistent with the functions of a building. Now that, in my submission, is a mischaracterization of what was decided by the first tier. It had made specific findings of fact as to the functions that were actually performed. And what it held was that on the facts, those functions were functions of buildings. So that is a misdescription of what was actually done. And again, the weight to be given to those matters was a matter for the FTT. So the FTT took the right approach, but I do also submit, if I'm wrong about that, if as a matter of construction one were constrained to say, well, one has to give greater weight to function, then I make the point that I do at paragraph 53 in the skeleton, that when you actually look at the findings as to what these facilities are and what they do, given what has been constructed, these items, on any sensible view, would still count as buildings, because you still have a detailed functional analysis that's been properly performed by the FTT. But I put the case in two ways under ground one. First of all, the UT was wrong to adopt this limited construction of the term building, giving a predominance to function. But even if that was the correct approach in law, and I say it's not, it still doesn't undermine the findings that were actually made by the FTT. So that was what I proposed to say on ground one. And with your permission, if I could pass on to ground two, which is in the skeleton at paragraphs 54 to 65. And this is the upper tribunal overturning the first tier's decision that many of the disputed assets didn't constitute plant for the purposes of section 11 sub A sub 4 in principle. So that's leaving to one side the effect of sections 21 to 23. And my submission is that the FTT was fully entitled to conclude as it did. The upper tribunal was wrong in law to intervene. And I showed the court this morning the starting point for an appeal on this sort of question. That's Cheshire Cavity, paragraph 3. We're dealing with a question of fact or a question of fact and degree. It's a value judgment, and all the well-known principles apply to constrain the scope of an appeal on an issue like that. And it's also relevant to highlight, and again, we looked at these points this morning under reference to Cheshire, and particularly Wimpey and Warland, that first of all, an item may pass the business use test but fail the premises test. That was the insight from Mr. Justice Hoffman, approved by Lord Justice Fox, and then approved again in Cheshire Cavity. And then secondly, while of course it's true that it's right to consider the function of the item in dispute, the real question is, what does it function as? Is it functioning as premises, or is it functioning as apparatus? And again, that's Cheshire Cavity, paragraph 60. Now, I don't understand there to be any real dispute about those background principles. What's controversial is whether the upper tribunal was right to diagnose an error of law. So can I please deal with each of the alleged errors in turn and make my submissions as to why none of these matters entitled the upper tribunal to intervene. The first is in upper tribunal paragraph 80, and this is where the upper tribunal criticises paragraph 95 of the first tier's decision. And the upper tribunal proceeds essentially in two stages. They start by saying that the functionality test, that's got to be applied by reference to the taxpayer's business as it's actually carried on. And they say in the light of that the functionality test was misapplied because, in that, the FTT said that without the safety significant structures, the actual processes carried on at TMF could still be carried on efficiently, although that was theoretical, because the regulatory environment wouldn't permit it to happen. And two, that the regulatory environment was not relevant to whether an asset performed a function in the trade. And the upper tribunal went on to describe what was essentially that same point in paragraph 80 in a couple of different ways in 82 and also in 83. And I'll deal with those in turn. But my overarching point is that if one looks at paragraph 95 in the FTT's decision, the upper tribunal has mischaracterized and misunderstood both the question at issue and also what the first tier decided. And there was no error of law in my submission in paragraph 95. The FTT started by identifying what the trade was, and it made a finding as to that in the second sentence: deconversion of tails so as to produce and store uranium oxide and to produce hexafluoric acid for sale as an industrial material. It then found that the safety functions of shielding, containment, and seismic qualification, so they were the particular functions of the safety significant structures it had identified at paragraph 26, that they were properly viewed as part of the setting in which that trade is carried out. And it drew an analogy between shielding and containment on the one hand and the prevention of noxious fumes or odours escaping a processing plant on the other. What it then did was look at Wangaratta, which is the Australian case, and I'll address you specifically on Wangaratta in a few minutes. And it drew a contrast with Wangaratta, because it says in 95 that in Wangaratta, the structure was part of the dyeing process, because it actually removed volatile gases and liquids which would have affected adversely the dyeing process. It then said that's not the case here. The safety significant structures provide a safe setting for the processes to be carried out. And it noted that at least theoretically it was possible to do the processes, albeit that was a theoretical exercise, that analysis, because the regulatory environment wouldn't permit it to happen. And that was what then led it to say that the regulatory environment was not relevant to whether an asset performs a function in the trade. And the FTT then observed that in providing shielding and a containment, it couldn't be said the structures of any function in the actual processing of tails carried out by the plant and machinery in the TMF. Now, in its criticism in paragraph 80, I say first of all that the UT lost sight of the point that the FTT found as a fact that the safety functions of shielding, containment and seismic qualification, they're properly viewed as part of the setting. And it also misunderstood the question that needed to be asked, because of course the relevant question is whether the items that we were arguing about were functioning as plant or as premises. And whether something is required by regulation does not help you in addressing whether something is functioning as plant or as premises. It gets you to a place where you may need the particular function, but it leaves as large whether what the thing is functioning as is as plant or as premises. And just in that context, and in justifying, or for me to justify my point that the finding that the safety functions of shielding, containment and seismic qualification were open to the FTT, it's relevant just to reflect on Bradley and London Electricity. There's a summary of it, which you'll do for my purposes in FTT paragraph 83. As you can see in particular that in Bradley, this was the substation. We can look at it in the original if you like, but this will do. It's at volume 2, tab 24. But paragraph 83 will do. It's the electricity substation. The structure was designed to include a system for cooling the transformers, and that was actually provided by the structure itself. In particular, the walls were designed to withstand explosions, and the roof was designed to support earthing switches. Now, notwithstanding all of that, what Mr. Justice Blackburn held was that we were not dealing with a plant-like function. And what he said, and you can see this in the first quotation, that although the substation was specially designed for the trading activity and it couldn't sensibly be used other than for the purposes of that activity, that doesn't mean that it's plant. And it wasn't enough, said Mr. Justice Blackburn, to point to particular features of parts of the structure that perform plant-like functions. The FTT sets that out at paragraph 84. You had to look at the overall function, and although the structure was carefully designed to accommodate the equipment within, that didn't alter his conclusion that it was the premises. Now, I say that analogy with Bradley and London Electricity, that shows that the FTT was certainly entitled to find, as it did at 95 and 96, that those containment, shielding and seismic qualification functions, they were functions of premises, or adopting its language, part of the setting. Because if you look back in the FTT's decision, paragraph 74 illustrates that it was using the term setting and the term premises essentially interchangeably. The more general point, of course, is that we know from Cheshire Cavity that just because the asset in question has some trade function, that's not enough to make it plant. And so if one simply said, well, is this required by regulation? Answer, yes. That doesn't actually help you in the evaluative exercise that has to be undertaken. Indeed, there's an inconsistency in the UT's own judgment here, because at paragraph 85, the upper tribunal accepts, it's about eight lines down, that the FTT had been right to hold that an item is not plant simply because the business couldn't be carried on but for that item. So it's not a but for test. There's no challenge to that conclusion. So what needed to be done was to test whether the disputed assets were properly characterized as plant or as premises. And the approach the FTT took in 95, I say, was a perfectly permissible one. It's also, in any event, very clear that the FTT did have well in mind that there was a regulatory environment which had an impact on what could and couldn't be done, or how things needed to be done at sites. You can see the FTT referring to that regulatory environment, starting off at paragraph 24 in its decision, and it makes a series of findings about what is required, and it did, I say, take due account of it in the application that it made of the premises test. Now, and this is where we start getting into what is probably the same error in the view of the upper tribunal, but being described in different ways. The second point that the upper tribunal made was in its paragraph 82, where it said that while it acknowledged that the weight to be given to the applicable regulatory regime in making the functional assessment was for the FTT, it thought that the FTT's error, this is 5 lines down, was to confuse the relevance of the regulatory/safety aspects in assessing the functionality of the disputed items with their relevance to the nature of the business in which functionality was to be assessed. And they said that regulatory constraints, they determined what business URENCO could permissibly carry on at the tails management facility in the first place. Now, here the UT's misunderstood the nature of the evaluative exercise that needs to be performed, because the mere fact that safety functions are being fulfilled didn't and couldn't entail that the disputed assets were plant. We're back to the same point. What the FTT had to do was to assess in what way are the disputed assets functioning. Are they functioning as plant or are they functioning as premises? And what is absolutely clear is that the FTT made findings about what the business was. And the key finding is that second sentence of paragraph 95. It said it was deconversion of tails to produce and store uranium oxide and to produce hexafluoric acid for sale as an industrial material. That's what it then assessed. And what was required by regulation, I say, simply did not and could not inform the answer to the question that the FTT needed to address in assessing whether the disputed assets were premises or plant. The same point arises in relation to UT paragraph 83, where they say that it's the same confusion that lies behind essentially the penultimate sentence in FTT 95, they say. And the upper tribunal doesn't like this, because they say if the trade is itself shaped and determined by the regulatory environment, that environment must necessarily be relevant to assessing functionality in the trade. But all of this overlooks the fact that those functions, they could be performed by plant or they could be performed by premises. And if you look at this in context, given that the FTT has already found that the disputed assets did indeed have safety functions, namely shielding, containment, and seismic qualification, what the FTT in context is saying in that sentence when it says the regulatory environment is not, in my view, relevant to whether an asset performs a function in the trade, it's saying that it's not relevant to whether a function is performed as plant in the trade. That's the question that the FTT was actually having to address, and which in my submission it was addressing, because it had recognised expressly that it was dealing with functions. Clearly those are trade functions, but its view was that those functions were functions of setting, not of apparatus. The second error that the upper tribunal purported to diagnose, that comes in 84 and 85. And here the upper tribunal complains, as the start of 84, that in its view the FTT appears to concentrate unduly in determining functionality on the actual processing carried out at the TMF. And I say that that's a misunderstanding both of what the FTT decided and also of the nature of the test and the nature of the analysis. It would be a very surprising error for the FTT to have made, because it had directed itself, if one goes back to FTT paragraph 89 sub 3, that the function of plant in a trade can be active or passive. So we know from cases going all the way back to Gerald and John Good that it is possible to have an item of plant, which item of plant functions passively rather than actively. It doesn't follow, however, from the fact that the function of plant in a trade can be active or passive. It doesn't follow that an item which has a passive function in a trade must, as a matter of law, be characterised as plant. And you can see that from Gerald and John Good itself, and this was a point I think we touched on very briefly looking at Cheshire Cavity. Lord Justice Pearson, in relation to the partitions in Gerald and John Good, he says, and it's page 225 of the report, bundle page 67, we don't need to go there, he said that either view could have been taken. So it's a question of fact and degree in the particular circumstances of the case. And so while a tribunal would misdirect itself if it said a passive function can never be a plant-like function or something to that effect, it's perfectly legitimate for a tribunal to take into account as part of the evaluative exercise how active or how passive the functions happen to be. And that's consistent with the point that, of course, two things can perform exactly the same function, and yet one can be plant and the other can be premises. Ultimately, as I've said this morning, what one's got to ask is, what is the thing functioning as? So there's nothing in those criticisms. There's also what appears to be a background error on the part of the upper tribunal, which it doesn't particularly relate to its analysis, but which looks like it infects the analysis. And this is the point that the upper tribunal makes in paragraph 76 of its decision, bundle page 164. It says there that an item or structure which fulfills both functions, that's plant on the one hand and premises on the other, will nevertheless be plant because it is not merely the setting for the business. Now, that's actually not quite right, because the question is whether each of the disputed assets did in fact fulfill that function. And as we saw in Cheshire Cavity, that may well require asking the question whether it's more appropriate to describe the item as apparatus or as premises. And what you can see in the FTT's decision is actually that approach in action. That's what, in concrete terms, it's doing, particularly in 95 and following. It is testing how those assets are properly to be described. And having found, I say perfectly permissibly, that the main functions that were being relied on, those safety functions of shielding, containment, and seismic qualification, that they're functions of setting or premises, that's 95, it's perfectly legitimate for it to go on in 98 to address in detail the question, well, okay, what else is there that's happening? That's what it actually does in 98. It looks closely at what each of these items is doing, over and above safety functions and seismic qualification, which you see at 96 it regards as incidental to ensuring the integrity of the shielding and containment functions. And for a small number of the items, it says, okay, that there is enough, there is a sufficient role here that it is proper to characterize those items as on the plant side of the line, but for the bulk of the items, they are on the premises side of the line. There's nothing eccentric or misguided or incorrect about that exercise. The third error that the upper tribunal sought to diagnose comes in paragraph 86. And this is dealing with the Australian case of Wangaratta. The upper tribunal doesn't go quite so far as to say that it thinks that the FTT should have followed Wangaratta, but it does seem to criticise the approach of the FTT, because it says if the FTT had adopted the correct approach, And so that seems to be taking greater account of regulation and this point about active-passive, both of which I say are misguided, but that it should have made a much closer comparison to the complex whole in the Wangaratta case. Now, my point in answer to paragraph 86 is that the FTT was absolutely right to distinguish Wangaratta. And actually, one has to be very cautious nowadays about Wangaratta and what it decided. Can I just briefly show you the judgment itself? It's in Authorities, Volume 1, at tab 11. It's a decision of the High Court of Australia, but sitting as a first instance court. And you can see from the head note, bundle page 207, that what we were dealing with was a dye house. And the dye house involved dipping wool tops in vats, and there were hot, corrosive liquid dyes. And the dye house had various pits, and there were specially designed drains, and there were structural features in the wall that helped a ventilation system. Now, the finding was that other than some external walls, the whole of the dye house was in the nature of a tool. And the finding, as I'll show you this in the original in a minute, was that it was all an essential part in the efficient and economic operation of the taxpayer's business. And so held it was plant for the purposes of the Australian taxing statute. And you can see the essential reasoning. There's more to it than just this, but if I can pick it up, just given the time, at page 10 of the report, bundle page 216. Could I just ask the court, please, to read from the second hole punch, bundle page 216, to the end of the sidelining on page 217. And I'd underline the finding structure. It was an active tool in preventing spoiling of material. And you can see later the drains, they didn't just remove waste liquids, they removed volatile liquids that would disrupt the process, just as much as vapours, etc. And that if the boiling liquids were left uncovered, the whole process would quickly become unworkable. It was those matters that meant that the dye house as a whole, you see this right at the bottom of 216 and then to the top of 217, should be regarded as a single unit of plant, not a collection of bricks, mortar, paint, timber, etc., each of which is to be separately examined. That was what founded the Australian court's conclusion that this was a complex whole in which every piece is essential for the efficient operation of the whole. Now, critically, there is no analogous finding here that permits such an analysis to be made. What the FTT did, and you can see this in its findings at 72 was not to regard each facility as a whole, i.e. the kit and equipment within them and the structure itself and everything else. There's no finding that justifies that. What the FTT did in 72 was essentially identify the physical structure of each facility and then separately various other items. And it did not link those items to either particular items of equipment within each facility, nor indeed did it say that you need to look at the entire facility, including all of the kit within it. So that is a stark contrast to Wangaratta. And the FTT, when it's looking at Wangaratta and testing it, that actually makes even more sense, I say, of its observation about safe setting, because it recognises in paragraph 95 expressly that the dye house and the apparatus within, they'd been treated as a complex whole, every element essential, and it notes the role that the structure had in the process itself. And as it says rightly, that is not the case here, and that's because of its finding that what the structures are doing is providing a safe setting in which the process can be carried out. And so there's nothing in the point that impressed the upper tribunal that somehow this analysis is being done on a non-real world basis. You have to look at the trade in the real world. The tribunal looked at the actual trade, and it made a finding about what the trade was in the second sentence of 95. And what it's saying is that having made that finding, its view is that the safety functions being performed are premises functions. One also has to bear in mind, and this is the point I make in the skeleton, what Wangaratta, it is now quite an old case. It has been referred to in some of the English authorities, but it's decided in 1969 at a time long before the more sophisticated development of the premises test. And so one does have to take considerable caution in my submission with what one actually does with Wangaratta, because at the very least it's questionable whether another tribunal looking at the particular structure in that case would in any event have reached the same view as Justice McTiernan if one were to apply the principles recognised, for example, by Mr. Justice Hoffman. So I say, and this is the easiest point, it is readily distinguishable, Wangaratta, and the FTT was right to distinguish it. And actually, if one's really going to drill into Wangaratta, it may well be one of those cases that is now best regarded as confined to its own facts. It may even be a case that one might say, given the developments in the law subsequently, actually it may be better regarded as wrongly decided. But I don't need to go that far for the purposes of this appeal. It's enough for me simply to say that the FTT made no error of law in distinguishing Wangaratta. So, in my submission...
Sorry, just before we leave Wangaratta, you
yes.
said at the beginning it was the High Court of Australia sitting at first instance.
Yes.
It took me slightly by surprise.
Yeah, well,
that's right.
I believe so. Because
it was obviously on an appeal from some kind of experience.
I'm not sure it even was that, my lord, because you can see it's an appeal against, sorry, bundle page 208, appeal against an assessment. There's no first instance decision, and then a view is made. One sees second hole punch, page 209.
Oh, yeah.
And if one looks just at the procedure, so this is between the hole punches on page 208, it's an appeal to the High Court against assessments. There doesn't appear to be any commissioners stage. I'm afraid I can't really help with the general jurisdiction of the High Court, other than to say that that point had given me pause a few days ago. Having looked it up, it appears that the High Court does have at least some original jurisdiction, and it seems that was what it was exercising in this particular instance, but I'll no doubt be corrected if I've gone wrong about that, but I don't think I have.
Thank you.
So my core point, and this is obvious. I mean, there's a self-direction by the FTT as to the principles in paragraph 89, which was not subjected to any real criticism. Indeed, the UT recognised that essentially the correct propositions had been identified. The only thing one might say actually would be a point for me that 89 sub 6 is arguably too generous to URENCO because it may not fully capture the more appropriate question that needs to be asked, although the FTT was clearly well aware of that because it cites that language of more appropriate from Lord Justice Peter Gibson in Atwood and Anduff in the previous paragraph. So having identified the right principles, one would expect that the FTT had then gone on faithfully to apply them. That's the normal approach that an appellate tribunal would be taking. It wouldn't be astute to uncover an error of law. And I do say that in focusing in the way that it did on paragraph 95 in particular, both the point about regulation and also what it said about active-passive, both in relation to 95 and then the analysis that comes at 98, the upper tribunal failed properly to recognise the question that needed to be asked. It failed to look at the FTT's judgment as a whole, and it purported to diagnose an error of law when actually no such error existed. So it shouldn't have intervened. I also say that even if it's right that there were merit in one or more of those criticisms that I've sought to address, and so there was an error of law in the FTT decision in one or more of the respects that was identified, when you look at the findings of fact, I say it would clearly still be more appropriate to characterise these functions as being functions of premises and not of plant. And so what the UT should have done was to have held, as in, for example, the de Gorse case, that actually such error as there was not material. Now, the UT said, oh, well, it might have been different. I say, looking at the findings that have been made, actually the conclusion that we're dealing with premises functions is inescapable in any event. So even if there is a quibble about either regulatory environment or about active-passive, I say it wouldn't justify setting the decision aside in any event. The last point on ground 2 is, suppose you're against me on all of that, and you say that the upper tribunal was right to diagnose an error of law and to remit. There is a slightly odd point in that the upper tribunal seems to have said that it's only the items that were held not to be plant that should be remitted for further consideration. And I simply say, bearing in mind the upper tribunal's own observations as to disposition, that actually there may, on its view of the remitter, need to be additional arguments and evidence, in particular 173, that if there is to be a remitter, it should extend to everything so that the FTT can look at all matters in the round. Now, Mellor, of course, doesn't like that. He wants to bank the items that he won on. But I do say that if it is the case that there were to have to be a remitter, and of course I, on my analysis, never get there, I would just respectfully observe that fairness should require that that remitter should extend to all the items at issue so that the FTT can take an overall view. So, my lady, those were my submissions on ground 2, which only leaves me ground 3, which I can deal with actually rather more shortly. So I may even be ahead of my promised 3 o'clock, but I'll see how I get on. Ground 3, we address in the skeleton at paragraph 66 to 71, and this is quite a short point. It concerns the upper tribunal's conclusion that the first-tier decision that expenditure on the vaporisation facility walls and first-floor slab was not on the provision of plant and machinery was erroneous in law. That's what we're dealing with. So can I just start with what the relevant ruling was? So what did the FTT actually decide? And to do this, I suppose I should start with the structure, or the item that was identified, which you can see in 72 sub 2. So bundle page 235, the items which comprise the vaporisation facility can readily be seen to form a separate structure and to function as such. And that included the first-story concrete box, and Mr. Nicholson, one of the witnesses, had described that as a monolith. So if one goes to the block diagram, essentially it's the raft slab, it's the external and the internal walls, it's the first floor slab, and so on. The exception was the stairs and access platform, so that wasn't part of the item. There were also some steel supports and inserts which were agreed to qualify. And then there's an upper story, and that is, I should just tell you what colour it's in, because the one I printed isn't in the colour. It's brown. The element in brown.
Brown is accepted as not qualified for allowance.
Exactly, because that was just a roof functioning as a roof. Even Learned Friend accepted that. So it's everything in grey, forming one item for these purposes.
Generally speaking, it's the grey that we're concerned with.
Correct. And then, so that's what we're looking at. And then in terms of the ruling, so it looks at the structure. This is FTT 98 sub 5, bundle page 242. So it looks at the structure, excluding the upper story and the ground floor lean-to, which we've just been discussing. It says the functions are shielding and containment. It's essentially a concrete box which provides a setting for the autoclaves and associated equipment. It also, as it happens, is another example of shelter being provided, because those autoclaves, they weren't designed for outside use. But that's in danger of me trespassing on ground one. It notes, looking at the structure as a whole, the functions are essentially functions of premises rather than functions in processing tails. It looks specifically at the walls and the first floor raft slab, and they say they also provide support for pipework necessary for the processing of tails. But the conclusion is, in my view, that's also essentially a premises type function. And so the general conclusion refers back to the cylinder handling facility. I regard the vaporization facility as part of the setting. I do not accept it can be regarded as expenditure to make the plant in the facility usable. And if you look at what had been said about the CHF, you've got 98.1, purpose built to house the plant, 4 lines from the bottom, not part of the complex whole in the same way as the dye house was in Wangaratta. And then there are specific findings about internal partitioning and the like. But what you've got in relation to the vaporization facility is a clear conclusion that the functions are functions of premises, and a rejection of the factual case that this expenditure can be regarded as expenditure to make the plant and the facility usable. Now we know, and this was in Bradley and London Electricity, that the mere fact that a structure has been carefully designed to accommodate the equipment within it, that's not enough to make it plant. Ultimately, what the FTT had to decide was whether that expenditure was better characterised as expenditure on the provision of premises or as expenditure on the provision of plant and machinery. And I say simply, looking at 98 sub 5, that's exactly what it did. And that's a conclusion on a question of fact and degree. When you look at what the upper tribunal did, paragraph 99, there's a reiteration, and this is correct, that it's not just a but-for test. So So it says the FTT was justified in rejecting the submission that the expenditure had to be on the provision of plant simply because the plant couldn't be operated or couldn't be operated safely without it. So it's not a but-for test. It also agreed that where expenditure was not on the provision of plant because it was too remote, then where the FTT had found that, that was a finding of fact and the correct legal principles had been applied. But then paragraph 103 is where the UT says that the FTT went wrong. And they complain, first of all, that it's not clear whether this is on the basis that the vaporisation facility isn't plant or on the basis that the expenditure wasn't on the provision of plant. I mean, that's a quibble. Ultimately, there's only one statutory question. Is the expenditure on the provision of plant? There may be cases where one looks to get there parasitically. What they go on to say is that if we're looking at on the provision of, the FTT's reasoning indicates that it misdirected itself as to the law, it says. And the reason that's identified is because the UT says that the fact that the walls and the slab themselves performed a premises-type function was not material to whether expenditure on those items was on the provision of plant. It says if the expenditure fell within the principles we described above, then the fact the expenditure happened to result in physical items which performed a premises function would not render it ineligible. Now, the principles that the FTT describes above are principles in particular in Benedico, Berkeley Curl and the like, that expenditure on the provision of plant and machinery can go further than simply providing the item itself. It can also extend to installing it, making it operable. But the problem with all of this is that the FTT, if one looks back at FTT 98 sub 5, the FTT has expressly rejected the argument that the expenditure can be regarded as expenditure to make the plant in the facility usable. That's the last sentence of 98 sub 5. And that's perfectly in line with, for example, Bradley and London Electricity. All you've got is, and let's just use a neutral word of structure, a structure that has been designed specifically to accommodate the plant. There's then, of course, a question in those circumstances: is the expenditure properly characterised as expenditure on the provision of the apparatus itself, or is it instead, as was found in Bradley and as I would say is correctly found here, is it actually expenditure on the provision of premises? And so I simply say this is a factual conclusion that shouldn't have been reopened, and stand back from this. It's absolutely right. What the FTT was looking at was providing support for pipework, and a structure doing that is an ordinary premises type function. Now, Mellor tries to uphold the upper tribunal's conclusion, this is particularly his skeleton paragraph 82, by saying that the FTT made a false assumption. And he says that the assumption was that expenditure on the provision of plant is disqualified if it is also expenditure on premises. That complaint is wrong. The reason it's wrong is that Mellor did not get a finding from the FTT that this expenditure was expenditure on the provision of plant. So there's no such false assumption. What the FTT did was it rejected URENCO's argument that the expenditure was to make the plant in the facility usable. And for that reason, Mellor gets no help from cases like Berkeley Curl. Because on the facts in Berkeley Curl, the expenditure was part of installing the dry dock. You had to excavate it in order to have a dry dock in place. It doesn't follow from that walls that contain pipework must, as a matter of law, be regarded as plant. So in my respectful submission, the upper tribunal went wrong in diagnosing that further error of law in relation to the on the provision of issue. So, milady, that sets out my submissions on grounds 1, 2, and 3. And the overarching submission is that the UT was wrong to find any error of law in the decision of the First-tier Tribunal. The First-tier Tribunal was perfectly entitled to find as it did, and its decision should have been upheld and not set aside. If you're with me on the grounds of appeal, I'd invite you to allow the appeal. And those are my submissions.
Thank you very much indeed.
Mellor and friends made a number of points by way of general introduction this morning before he came to grounds 1, 2 and 3. I ought to pick up one or two of those. The court will well have in mind that whilst these particular assets are unique in the UK and possibly around the world, this case and the issues between the parties in relation both to the common law and the meaning of building, and when we get that far to list C, are of considerable wider interest to all those who are concerned with either making or considering claims for capital allowances. So it is about a set of rather unique assets in a particular industry, but the questions have much wider import, as one might expect. Secondly, my clients would be keen for me to make clear an answer to my Lord Justice Arnold's observation that Capenhurst is a secure site as a whole. There are a number of safety measures and safety assets in place on the site that were not part of this dispute. They were not addressed below because they're not relevant. But to give you a measure of the concern that my clients have about security as a whole, the photographs and the plans that were before the first hearing, which you have in these bundles, has to be security cleared before they were made more widely available. Now, none of that is relevant here to the assets we're concerned with, but the court shouldn't have the impression that there is any kind of security or safety difficulty that is relevant to the site or indeed relevant to this dispute.
Thank you.
It is, of course, the case that the tribunal had the benefit of a site visit. That was indeed useful. Tribunal saw the various assets in their then state of construction. We went before the hearing because if one were to go now, one either can't stand in the places that we did stand, or if one did, one would be fairly seriously ill fairly quickly. So there were practical advantages in going when we did, but ultimately, of course, those were matters for the first-tier tribunal. It made detailed findings of fact, and it was no part of my case in the upper tribunal, nor part of my case here, that we're challenging findings of fact. This is about matters of legal principle. My new friend made an observation in relation to that when he said that the question of whether a common law, an asset might pass the common law test of plant, is a question of fact or a question of fact and degree. Of course, he's right in a sense, but of course one has to determine what is meant by plant as a matter of law, and when we get to it, I'll show you a couple of authorities that make clear that that is a judge-made rule. So the meaning of plant is a matter of law. Once one has properly identified the meaning of plant, then the application of that term in a given case is a matter of fact. But I'll come back to that in a little while. Like my learned friend, I'll try and use neutral terms when talking about the various assets. So I may talk in terms of apparatus or kit, meaning plant or machinery, for which there is no doubt that allowances are available. And I'll try and talk in terms of facilities or structures, so as not to beg any other question. My friend identified some of the relevant purposes for which these particular assets were constructed. He mentioned radiation shielding, radiation containment and seismic qualification. That doesn't actually quite reflect the findings made by the first tier. In two senses. One is, one of the purposes was not just radiation shielding, but also radiation reduction or attenuation. Because we had evidence before the first tier that if you have concrete that is thick enough, that both shields radiation, but it also reduces it because of the effect of the concrete on the gamma particles. More significantly, what he didn't mention is that there are chemical hazards on site, principally the gas and then the hydrofluoric acid, and they are part of the process or part of the purposes for which some of these assets were built, and that's reflected in the First-tier Tribunal's decision. One needs to read from 29 through to 33, but the chemical hazards are addressed in paragraph 33. Now, there's a point also about the scope of this appeal. My friend vaguely this morning, faintly this morning, and then much more loudly this afternoon, ran a contention to the effect that even if the upper tribunal were right to find that the first tier had erred in law, it either should have confirmed the conclusion of the first tier for different reasons, or it should have not remitted the matter and decided that for itself. Now, that type of contention is not open to my learned friend because he has no ground of appeal to that effect. So he has not appealed to this court on the basis that even if the upper tribunal were right to find errors, they should have confirmed the decision and or not remitted. It may be that's not going to matter, but it's important that I identify that as an issue at this stage. As far as we understand the scope of the appeal, reflecting the grounds of appeal, is that we challenged the conclusions of the first tier as a matter of law in the upper tribunal. The upper tribunal agreed with some of our contentions and rejected some others. Where we lost, we appealed. When my learned friend lost, he appealed. But he didn't go on to say that even if there were findings that reflect errors made by the first tier, the result should still have been the same. So in effect, the only questions on this appeal are whether the upper tribunal were right to find, or on my appeal, not to find errors of law made by the first tier. My friend showed you the architecture of the legislation, some of which I'll have to come back to. But 2 points I should make clear at this stage. There was a dispute until relatively recently as to the 2 limbs of Section 22. So you perhaps recall he showed you Section 21 that deals with buildings. Section 22 deals with structures, assets, and other works. And Section 22 has 2 limbs to it. There was a debate prior to the decision of this court in SSE as to whether those 2 limbs were mutually exclusive. And this court concluded that they are. The commissioners tried to pursue that point to the Supreme Court, but were not given leave in relation to it. Now, SSE is going on, going to be heard in March of next year, but not in relation to the point about whether the 2 limbs of Section 22 are mutually exclusive. And that's why, here, thinking about the logic of the arguments, if we pass the common law test and we're not a building, then it is common ground that we are a structure, but we're a B7 little a structure that would give us an entitlement to allowances. But one only gets there once one knows that the 2 limbs of Section 22 are mutually exclusive. And that's Lady Justice Rose's decision in SSE. Secondly, a much smaller point, but still of some significance when we get there, my own friend said this morning that Section 21 was designed to deal with the results in Berkeley Curl, the dry dock, and Schofield being the grain silos. And we know that's not right. What is now Sections 21 to 23 had a different form when they were first introduced in 1994. So there were, in effect, 2 rules and 2 tables by way of exceptions, 1 table per rule. And the exceptions relating to dry dock and silos were exceptions to structure and not exceptions to building. I'll come back to why that might matter, my learned friend is, I'm afraid, wrong to say that Section 21 was designed to deal with either of those cases, because we know Parliament thought otherwise. So I'll come back to the legislation in due course. I'm sure the court has this in mind, having looked at the decisions below, but that process that you saw the beginnings of with Mr. Dorrell led to the Finance Act 1994, which amended the 1990 Capital Allowances Act. That does have a different structure and a different order. It was then the subject of a tax law rewrite project consolidation in the 2001 Act, which is what leads to the format we have now. And there are differences between the two, and those differences become acute when we get to List C. Again, I'll come back to that. As to the disputed assets, I don't need to take up time with this, but I do urge, as I'm sure you will, to go back and look very carefully at the description of the assets and the findings made by the First-tier Tribunal. The description are in first-tier paragraphs 14 to 18 and 41 to 60, and then the descriptions of the relevant processes at the tails management facilities are in paragraphs 10, 14 to 18, and then 28 through to 33. And I do urge upon you careful consideration of the block diagrams that we use to illustrate the debate in both the first tier and the upper tribunal, to be seen or to be examined alongside such photographs as you find appropriate. In that regard, my learned friend read a particular paragraph from the first tier decision and then showed you an external photograph, no doubt with the proposition in mind that, well, the photograph makes it look like a building. Of course, what's significant is what he didn't read out of paragraph 39 of the first tier's decision. So I'll just identify it for you. It's in the core tab 17. And what he read to you was that they have the appearance of a single modern industrial type building, albeit with different roof heights. The CHF and the UOS give the appearance of being large warehouse type structures. This is the effective part of the external cladding. Then you missed the next couple of sentences. It was a condition of the planning permission that the facilities have the appearance of a modern business park. The site is very close to local community facilities. Despite appearances, each of the facilities under consideration is structurally independent. So my learned friend is quite entitled to show you those external photographs, but one has to realise that that is external cladding for aesthetic and planning reasons. What we're concerned with are structurally independent facilities inside that inner skin. So the relevant question when we get there is, are those independent facilities properly to be regarded as structures or as buildings? And then the last point by way of introduction, my own friend identified in outline the debate that we'd had before the first tier as to the level of generality that you ought to apply in testing these assets. And he's right to say you could have looked at the thing as a single item, or at the other extreme, you might have examined every nut and bolt. And the case law establishes that the height at which you judge these plant and statutory questions is a matter for the first tier tribunal. So in the first tier, there were different views proffered by the parties, and what the first tier did was to treat each of the facilities as a separate whole, with some exceptions to each of those separate facilities. But those exceptions aside, what the first tier doing is characterising each of those 5 independent facilities.
You say it's a matter for the FTT, which of course it is, but I mean, and so is everything else in the case a matter for the FTT. I mean, you're not disputing that, or are you saying it was a different type of exercise they had to perform? in relation to the level of examination from the assessment as to whether it was found for machinery, or is it basically the same type of exercise but just not appealed because both sides were content with their conclusions?
In that latter regard, yes, both sides accepted the approach of the first tier. It wasn't what I had proffered,
No,
tribunal
that's
nor
what I
my
thought,
learned
yes.
friend,
Yeah.
but neither of us got our preferred choice.
It came down in the middle somewhere.
The first tier picked, perhaps not quite in the middle, but picked a third course.
Yes, a third way, yes.
Neither side appealed that. That is a matter of fact and degree, and the authorities make clear that the entirety question is one of fact and degree for the fact-finding body. But our complaint in the upper tribunal, and by extension, I have to defend the upper tribunal decision, our complaint here about the first-tier tribunal is not a complaint about the fact-finding exercise or the evaluative exercise, because if that were my complaint, I would be wrong.
So effectively, you're saying they misdirected themselves in various material respects of law.
Yes, and either I'm right about that or I'm wrong, but we are not here purporting to refight the facts. Indeed, the facts as found reflected almost entirely the evidential case that we advanced. Not surprisingly, because my clients were the only people who had the detail to explain what these assets were and what they do. So I'm going to focus my submissions on explaining why the upper tribunal were right to find the errors that they did. And that, in our submission, is really the only point in my learned friend's appeal. So then let me tackle firstly the question of building. Now, as a marker in case it ever became important, we don't think it's sensible to start with section 21. We think you ought to start with the common law, because the common law can help inform the application of the statutory provisions. We said that below, it was accepted below, I still think it's right, but I've got to address both points anyway, so maybe it doesn't matter here.
Well, I suppose one thing you would urge against us doing is being tempted into taking the building issue as, so to speak, a potential shortcut.
Yes.
Because in view of the wider interest in all these issues, it's going to be helpful if we address them, whatever our ultimate conclusion is.
Yes,
right?
not least because the upper tribunal sent both issues back.
Yes.
And so it would be highly unsatisfactory if that was either a partial exercise or otherwise stymied. But given the interest that other builders of large assets have, I'll put that neutrally, in both the nuclear and other energy industries, the outcome of this case is, well, I mean, all decisions of this court are important. But there is a real importance here in understanding how these rules work. So, building, the court will have this in mind. We know that the Finance Act 1994 introduced 4 statutory exclusionary rules. Section 21 dealing with buildings, Section 22 dealing with structures, Section 22 also dealing with other works involving the alteration of land, and then there's one that we haven't seen yet but will become relevant on my appeal, which is Section 24. You can't get allowances for acquiring an interest in land. The purpose of those rules is perfectly fairly summarised by Lady Justice Rose's decision in SSE in this court, in her paragraphs 19 and 27. But that should come with a health warning, in that summary is a synthesis of a number of different ways in which Mr. Dorrell puts the purpose of the provisions in Hansard. I'm wary of this exercise because in one sense this is not pepper and heart and we shouldn't be looking at Hansard, but if we're going to look at it for context, one needs to see all of the different ways that he puts it.
We can look at it, can't we, for the purpose of identifying the mischief,
You can.
regardless of pepper and heart. And I take it that was the basis upon which it was looked at in this case.
It was. But I don't want to take up time, but if one needs to read on beyond the pages you were shown. Perhaps if we do it just quickly, it's volume 4, maybe coming back to this. Tab 53, Mr. Dorrell's the relevant minister. He's speaking to clause 110, which later becomes section 117 of the Finance Act 1994. And you were invited to read bottom of the right-hand column at page 1140. And then over the next page, left-hand column in page 1141 of the bundle. It's fair to say that Mr. Dorrell doesn't have a perfect grasp of the provisions. If one reads on in the left-hand column a little further in 1141, he was interrupted about a particular amendment. He says, all ministers rely from time to time on the advice of parliamentary draftsmen. I confess, young gentlemen, I have studied the text of note 2 to table 2 for some time. I'm not sure that it was clear to me precisely what it means either before or after the amendment, but I am now moving. However, I endorse entirely the policy objective which I am advised by Parliamentary Counsel is delivered by the amendment that he has proposed to me. Somebody had handed him a note and he still didn't understand the note.
Oh, I can sympathise.
Absolutely. But one needs to read all of his observations with that thought in mind. But if one reads on, because he comes back into the debate, so I won't read these to you, but page 1149 of the bundle, right-hand column, 10 lines up from the bottom, Mr. Dorrell, I've already made it clear that the clause's intention is to prevent further erosion of the tax base as a result of extension of entitlement to capital allowances. It will not remove entitlement to capital allowances from any taxpayer who is entitled to it under the present state of case law. And then reading on, because the debate was interrupted and they come back, page 1155 of the bundle, right-hand column, in the middle of that, Mr. Dorrell says, I can give the committee the clear undertaking that it is not our intention to change the capital treatment of any class of asset under the clause.
It's that type of statement that could have, in principle, have made a pepper and heart search and reliance okay had the revenue sought to go back on the assurances that were given.
And had this exchange read as a whole,
yes,
evinced a single clear intention, which
may well be quite a big assumption.
But yes, it just doesn't. So what Lady Justice Rose has to say is perfectly fine. I don't seek to undermine it. But if one wants to look more carefully and place any great reliance on exactly what was intended, then one needs to read all of Mr. Dorrell.
Yeah, and what he says in the passage you just referred to at 1155 has to be taken together with what he goes on to say in the paragraphs at the foot of the page on the right-hand column, where he's pretty clear that actually the objective is to curb court's interpretation.
My lord is right. He does say that, having said in a couple of places that's not his intention. Broadly speaking, this was an exercise in drawing a line in the sand, protecting those who'd established allowances already by case law or by revenue practice, and preventing there being any developments in the law that would give an entitlement to allowances that Parliament was now saying it thought were inappropriate. But one can't proceed from that summary at that level of generality to any particular conclusion about the statutory language. One needs to be very, very wary of that exercise.
One always has to be careful about metaphors. I mean, the line in the sand is normally taken to mean, that may sound rather kind of impermanent, but it's normally taken as meaning something beyond which you shall not go.
Yes.
Like why or how that metaphor evolved, I don't know.
Not least because, as we know, sands shift. If it had been a line in the concrete, it might have created permanence.
Yeah. Anyway, so there it is.
But what we do know, because we know this from the statute, is Parliament determined to to make particular provision for buildings on the one hand, and then make different provision for structures on the other. And the effect of that divide here, to reiterate the Court has got the point, is that if we are structures, then assuming we pass the common law, Parliament's intention was that we would get allowances. Conversely, if we're buildings, then Parliament's intention is that we would not. So against that background, what's the meaning of building in section 21? As my own friend has already showed you, there's no definition of building, but the section is expansive in that it includes, by way of a block on allowances, things that are incorporated in or in a building. But again, it doesn't define building. So the perfectly reasonable starting point is to say, well, building is an ordinary word of the English language, doesn't have a specific technical meaning, there is no baked-in special legal meaning. Indeed, even as a matter of language, it has an ill-defined, perhaps uncertain, range of possible meanings. One then has to move beyond that to say, well, what does it mean in this particular statutory provision, reading the provision purposively, but in the context of the statutory code as a whole. So you heard that from a learned friend, and we're ad idem about that. And he showed you the Morrison case, which was the rating case about the walls on the farm. You may not have picked this up, but there were in effect two assets in Morrison's. One appeared to be walls, my lord I suspect is right, dry stone walls, that enclosed a field. Relatively easy to form a view about whether that's a building or not. But there were also things called beals. You can still see these in North Pennine rural areas, which are in effect circular walls designed to shelter typically sheep.
So I think the cruciform was also, you get both types.
Yes, well, that's correct. And so the debate in Morrison was also about, are these beals buildings? And it was tolerably clear, given the context of the statute, that something that was just a wall, even in a particular configuration, looking at the character and nature and function of the item, was not a building. But Morrison's doesn't identify any matters of great principle, and of course it is a High Court case and not binding on this one, but in a sense there's nothing you could find in that case that you might even thought you were minded to follow. So Morrison's is interesting, but it doesn't really help. The case that is more important is the Guy case, which my own friend showed you about the crematorium. And here perhaps it would help to turn it up. It's in the second volume of Authorities, behind tab 23. That's a wrong reference. Behind tab 31, the decision of this court in 2010. And my own friend, I think, picked up the judgment of the Master of the Rolls, which begins, Court of Appeal begins at 539 of the bundle. So you'll see there his lordship at the foot of the page. And then it takes a number of paragraphs to identify that the case in the Court of Appeal was narrower than the case that had been fought below. And then you were shown, I think from paragraph 21 onwards, recording the submissions of Mr. Swift, the Secretary of State, that when considering the term building in the Crematoria Act, it has to be an enclosure of brick or stonework covered in by a roof. And then what his lordship says in paragraph 22, building must depend on the context in which the word is used. Yes, we agree. 4 or 5 lines down between letters E and F, he says one can usefully start as a starting point, usually take as a starting point the word's ordinary meaning. We have no difficulty with that. But he then goes on to say that that still has to be considered in its context. He makes the point in 23 and 24 that he thinks the ordinary meaning of building is actually wider than the view that attracted the court in the Moyer case. Well, fine, so be it. We're not unhappy with that. And he then makes the point, having made that point in 24 and 25, he makes the point in 26 that it can be an iterative process whether you look at ordinary meaning and context in one order or indeed in the other. We have no difficulty with that. But here, significantly, the context in that particular dispute is very, very different to the context in this. There was clearly a desire on the part of the court, if they could, to find a solution for Mr. Guy's wish to be cremated in what is in effect an open-air structure. And it was clear that there was nothing in the Crematoria Act and its use of building that would preclude cremation in a suitably constructed permanent structure, even if it had an aperture open to the air so that the sun could shine on the pyre. And it's that that leads his lordship in paragraphs 33 through to 37 to come to the conclusion in that case that building suggested a structure that is relatively permanent and substantial. And that comes from his paragraph 35 beginning in light of these factors and then reading on down to 37. 37 at letter H, a structure must, at the risk of an oxymoron, be relatively permanent and substantial. And we have no difficulty with any of that. That's a perfectly acceptable, perfectly sensible reading of that term in that statute. But it is, we say, no help here where the context is different. Now, perhaps by way of a footnote point, you have also shown Lord Denning's decision in the Windsor Hotel case. Well, again, one doesn't get any point of principle from that case, no guidance as to principle. It's clear on the facts that what was being built there under the guise of a barbecue was in effect some rather large, double-chinned, chimneyed outdoor kitchen.
What do you say about Lord Newburger's warning in paragraph 33 about the dangers of attempting to provide a definition of something which Parliament has deliberately decided not to define? Are you happy with that?
I'm happy with that. Because the exercise, as your Lordship perhaps has in mind, is not for this court to say we think building means X. Ultimately, the question is whether the upper tribunal were right to find errors, and that in effect means determining whether this either is or could be a building.
But the upper tribunal did at one point set out on what they termed a spectrum, various possible meanings. I mean, no doubt we'll be coming back to that.
Coming back to that. But I have, as a statement of principle, we would accept that as a suitable health warning to this court.
Thank you.
So we get nothing of principle from Windsor Hotel. There was some debate below, and it found echoes in what you heard from my learned friend today, as to the significance of function in determining whether an asset is or is not a building. Now, our case below and our case here is that function is undoubtedly a relevant factor, and one can't simply look at physical attributes or indeed the method of construction. Now, point taken against us faintly repeated again this morning is, well, if that's right, and we know that function is relevant to the common law question, how can it again either be relevant to or indeed significantly relevant to the statutory question? Doesn't that have the effect that somehow section 21 will be restating the common law test? And the answer to that is no. We know from the common law, for reasons I'll develop probably now tomorrow, that an asset can be common law plant if it has an apparatus function, and that asset may fairly be described as a structure, even though it has an apparatus function. So the dry dock in Berkeley Curl is a good example. And what section 21 is doing is asking a different question. It's saying, let's assume all of that is true as a matter of common law. Section 21 is saying, is your structure a building? So it's supplying a separate statutory test. And
But it could never bite unless the common law test was satisfied.
Unless the common law test is passed, we don't get to section 21 or indeed section 22.
So surely you would accept that we shouldn't construe section 21 as having redundancy in it.
And that, my lord, is my point. It's providing an extra test. So the common law test asks, I'll put it simply for now, does your item have an apparatus function? Does it function like kit or equipment? If the answer to that is yes, but it is still some structure or monolith, of which the dry dock or the grain silo are perfectly good examples, the statutory code now asks, are you a building or are you a structure? Because buildings don't get allowances and only some structures do. So section 21 is supplying a separate test over and above the common law test. But significantly, at the statutory stage, we have to draw a distinction between what here the first tier described as concrete boxes. I'll show you this in due course, but it says of most, or not all of these facilities, that they are in effect concrete boxes. You've got a concrete cube. What you have to determine is this concrete cube or concrete box a structure that we know is saved by B7A, or is it a building? And in answering that question, one is entitled, we say, to look both at the physical attributes of the item, but also at its function. Pausing there, I'll come back to that point in a second, but pausing there, the normal functions of a building are indeed to provide shelter and security to persons or items enclosed within. And one can see that in the judgment of the Vice-Chancellor in Carr and Sayer. It's about the kennels. That's tab 1, sorry, volume 1, tab 22, page 323. It's also apparent in a case you haven't been shown, but I'll just give you the reference. There was a dispute in a case called Andrews about a gazebo outside a pub. Was a gazebo a building? And there's recognition in that case that the typical functions of a building are to provide shelter and or security. So Andrews is at volume 2, tab 30. Equally, we know that buildings can contain, in both senses that my lord identified this morning. Perhaps the best example of that is a prison, which is discussed in Carr and Say. But not every asset that provides shelter is a building. And that may be for either or both of two reasons. Shelter may be entirely incidental to some other non-building function. That is the case here on the findings of fact as regards some of these assets. Or it may be clear from the form and characteristics of the asset that whilst it does provide shelter, it is not a building. The most prosaic example I can think of is those green boxes that you see at the end of roads that contain telephone switching kit. And the green boxes themselves shelter the switching kit inside. And in one sense, at least, they contain the switching kit. But it could not, would not be said that merely because they provide shelter or containment, those boxes are buildings. So not everything that provides shelter is a building. Not everything that provides containment in either of the senses identified by my lord is a building. Best example of that is gas tanks, or a gas holder. That has to contain the gas molecules, because otherwise they would escape into the atmosphere. But the fact that your asset contains the gas, a gas holder or an LNG tank, doesn't make that gas holder or the LNG tank into a building. And this is not just me asserting this. We know this on the authorities. So the grain silo in Schofield provided shelter and containment. It contained the grain. It also provided shelter from the elements of the grain and of the operatives inside, but it was seen as a structure and not a building. And that's in volume 1 at tab 14. You'll perhaps recall, we saw it in passing when we looked briefly at Berkeley Curl, that the House of Lords were troubled by an earlier decision of the High Court in a case called Margaret. It's about a water tower. And the majority of the House of Lords in Berkeley Curl say that Margaret is wrongly decided. Because what the High Court judge had decided was that a water tower that holds water at a height to allow gravity to feed it out to a town or a village wasn't plumbed. And the majority, 3-2 in Berkeley Curl, wrongly decided that it should have been plumbed, because the purpose of the water tower was to hold the water and to do so at a height to allow it to provide gravity feed. So when one looks at Berkeley Curl, it's volume 1, tab 10, one also needs to bear in mind what the House of Lords decided about Margaret's and the water tower.
Well, and the fact they were split 3-2 on not only the main issue, but also on the case about the water tower does show how difficult these cases are.
Look, it does, and there's a refinement to that they were split 3-2 on the main plant question. There was a separate question about on the provision of the excavation works.
Yes. Yeah.
They split 4-1 on that.
Right.
Forget now who was the dissenter who addressed both issues differently. But one of their lordships dissented on the main proposition but agreed with the majority on the secondary proposition. Now, the other point that my learned friend, he made 2 more points about the legislation. And here it would be helpful just to turn up section 21. This is volume 1 of the authorities. He made a point about section 21, subsection 3b. Subsection 3b said building includes an asset which, although not incorporated in the building, whether because the asset is movable or for any other reason, just pause there, it becomes relevant later, that section 21 recognises your building might be movable. It is in the building and is of a kind normally incorporated in the point he seemed to make was that, well, because there's a reference there to normally incorporated, that tells you you ought to take the normal or ordinary meaning of building. With respect, my friend, that's just a bad point. What the statute is asking there is the prevailing practice as to whether an item is normally incorporated in the building. It's not expressing a view about the meaning of building. His reliance on 21(3)(b) is a bad point. The other point he made about the statute was to say, well, you can glean something about the scope of building in section 21 from the ambit of list C20 and list C21. He said that a couple of times. And if one turns over, still in the same tab, list C, page 27 of the bundle, list C20 is the building provided for testing aircraft engines, and C21 is movable buildings intended to be moved in the course of the qualifying activity. Now, just by way of note, my understanding, though I can't prove it, is that C21 is there because of the movable kennels in Carr and Sayer. My Lord Justice Henderson may remember that there were movable kennels and permanent kennels.
Yes, I mean, the movable ones were the ones which the general commissioners found in favour of the taxpayers, and that went no further.
Yes.
Yeah.
And that's 1991, 1992.
Yes.
So it may well be, my suspicion, my belief is that 21 is about the kennels, that's why that's there. 20, I know of no case about aircraft engine testing buildings. I suspect that was one that reflected the revenues practice.
Yes. Well, movable buildings, I suppose another example could be mobile homes of one kind or another, the sort of thing you see carted around on the main roads. They get put down in caravan parks and things like that.
That is possible, although there is, I don't immediately see, but there are separate rules about caravans.
Okay, well maybe that was a bad example.
But more importantly, for the purposes of our debate today, what does the existence, or indeed the language of C21 and C20 tell us about the ambit of building? And in my respectful submission, the answer is nothing. We know that those are thought by Parliament to be within the concept of building. And that's not a surprise because 20 and 21 both use the term building. But does their existence or the language tell us anything about the scope of the notion of building? In my submission, no.
And in a way, it's a circular point, isn't it? Because it's just the same word is used again.
Correct. So if my learned friend is right, he doesn't need these, and if he's not right, they don't help him. So we are left in our submission with identifying the meaning of the term here in the particular context where you want to draw a distinction between building and structure. Now, at this point, we turn up the first-tier decision in the core bundle tab 17 and look at how the first tier dealt with this. So it's page 243 of the bundle, beginning at paragraph 100. Paragraph 100, he introduces the issue. Paragraph 101, he sets out the legislation. 102 refers to the drawing the line in the sand and what Mr. Dorrell had to say. 103, there's no statutory definition of the term building, no binding authorities. And then 104, he reflects, we say accurately, what we had said about the meaning of buildings, a broad English word which must be defined within its context and against the relevant statutory background. And then we discussed the Beals in Morrison. 105, the judge says he accepts my submissions which do not appear to be controversial. And then 106, the respondents, Mr. Bremner, contend the building has a wide meaning does not require artificial distinctions, and is to be given a meaning consistent with everyday usage. Well, that was a submission of a different approach. It's not the same as the submissions I had made in 104. And then Mr. Bremner also submitted that whether or not something constitutes a building depends not on its function. My friend was saying function's irrelevant. It doesn't depend on function, but on its inherent characteristics. So there were two different ways of looking at the world, starkly different. And then what the judge says in 107, I accept the word building is to be given a meaning consistent with its ordinary everyday usage. Well, we said in the upper tribunal, and say again, that that's inconsistent with what he'd accepted from me in 104 and 105. He then says, perfectly correctly, I do not consider that function is irrelevant. I agree that the function of a structure will be a factor that's not determinative. The inherent characteristics of a structure must be seen in the context of the function of the structure. Well, we have no problem with that. And then those functions might include providing shelter and security, common law test. Then he says section 21 requires consideration of the nature and characteristics of a structure, including whether or not the functions it is intended to perform. He says are typical functions of a building. One needs to be wary about that. That's what comes a little further down. And then 108 records our case as to these particular structures. And then 109, clear from Carr and Sayre that an asset does not cease to be a building merely because it's particularly suitable. Well, we accept that. A special building is still a building. We accept that. And then 5 lines down, it seems to me that in the context of a particular trade, one of the functions of a building might be to securely contain people or things. Well, that's true. One needs to underline might be. And then the Vice-Chancellor gave the example of a prison, and he goes on. And in 110, on my case, the question of whether a structure is a building only arises once it has been determined that it satisfies the common law definition of plant, correct? As such, it must be treated as having a plant-like function in the trade. One then looks to see whether it is also functions as a building. That logically is right. And he says, however, in my view, it's not solely a question of how the structure functions, it's also a question of the characteristics of the structure. For example, does it have the form of a building? A structure which has 4 walls and a roof might naturally be described as a building, whatever specialist function it might have. Well, in a sense, that's unobjectionable, but one needs to recognise that ultimately one has to construe this term in this particular statutory context. And he then goes on to address the assets in turn, but the way he addresses the building question is to identify whether, let me put it this way, the test that he applies is to ask whether a particular facility is naturally described as a building. And one can see that in 115, 117, 119 and 124. And we say that's an error of law.
Why? What's wrong with asking whether something is naturally described as a building? If you've got a structure with a foundation, walls and a roof, what on earth is wrong with saying that might naturally be described as a building?
As we'll see on a full reading model, that is one of the foundation stones of his conclusion. But why I say it's wrong in this context is that we know that there may well be large monolithic structures that may have particular characteristics that might naturally be described as a building. But in this context, one has to ask not is it naturally described as a building, but is it appropriate to regard it as a building and not as a structure? Because that's required.
But presumably you would accept that we would not attribute to Parliament the intention of using building in an unnatural sense.
Well, I'm not even
as
sure.
Describing things that would not naturally be described as buildings. There's nothing in the context to suggest that, is there?
I would accept from your lordship there's nothing in the context that suggests that. I'm wary of the wider proposition because this capital allowance legislation uses all sorts of terms in senses that may not be natural or usual or commonplace. When we come to look at
But in any event, he doesn't treat the question of whether the structures can naturally be described as buildings or the facilities can naturally be described as buildings as determinative, does he? That's merely part of his inquiry.
Can I read on, my lord, and see how he does do it? I'll come back to that observation. But there is evidence in here that what the judge was doing, when he says so expressly, is asking, is this particular facility naturally described as a building? He then also goes on to say that because an item can provide shelter, even if that's not its primary or predominant function, that is also part of his reasoning as to why here they should be seen as buildings.
Well, again, I mean, given we're dealing here with a question of fact and degree, is it not just a case of the FTT judge recognizing that questions of function are relevant, as are questions of how it's constructed, and the sort of immediate reaction of any normal person on seeing something with foundations, roofs, and walls and the roof is to say, well, certainly looks like looks like a building. So what's wrong with the finding that in this particular context that is the correct approach?
Because that doesn't give full respect to the divide that Parliament is determined here to draw between that which is a building and that which is a structure. Because we know from the case law that there were monoliths or structures that ex hypothesi could have a common law function that would make them prima facie entitled to allowances, where Parliament wanted to say all those people who've crossed the common law barrier, we're now going to divide you into two streams. One stream is building and you're barred unless you can be saved by List C. The other stream is structures where most of you are barred unless you're saved by List C, but some of you are not. And respecting that some of you are not, the exceptions to List B7, is what gives the necessary importance to the divide between building and structure when one looks at a monolith. So to say that it naturally looks like a building or might commonly be described as a building isn't enough.
I'm not sure I quite follow that. I mean, the purpose of List C is, and you accept, is to preserve the status quo in terms of decided cases and revenue practice. And that would therefore cover cases like Berkeley Pearl and the other, on the whole, perhaps outlier cases where it's been held that premises with a kind of apparatus function qualify as plant. But if you accept that those are expressly catered for by the 1994 legislation, what is wrong with giving building a natural and very broad meaning, or relatively broad meaning, in order to answer the prior question, is it a building or not? Parliament has deliberately given us next to nothing in the way of definition, and just a sort of almost a non-definition, saying it includes one or three specified things.
Two observations, Paul. First is you haven't seen this yet because we've not got to List C.
Yeah.
But in 1994 there were two separate bars and two separate relieving provisions. And things like the dry dock were relieving provisions from structures, not buildings.
But we have to start now with the consolidated legislation as it is.
We start with that.
Yeah.
Now there's a separate debate about whether are we allowed to look back, and I'll come
on to that. Yes.
But bear that in mind. But even in a world where we're not allowed to look back, Parliament intends that there will be some category of people who won't need to rely on List C because they are entitled to allowances because they're B7A A to C structures. And why does this matter? If B7 said any other structure without exceptions, then if you were a building you were barred, and if you're a structure you're barred. But because there are exceptions and because the two limbs of 22 are mutually exclusive, you do need to know the difference between building and structure. And so it's not enough in our respectful submission to say you can apply an everyday usage, or you can ask what naturally looks like a building or what naturally appears to be a building. Because you've got to contemplate, as Parliament well knew in 1994, that there would be structures that it wanted to preserve an entitlement to allowances for without relying on List C.
Isn't that a very surprising intention to attribute to Parliament, that a word as commonplace as building should have all this superstructure, so to speak, which one just has to infer from, you would say, from the wider statutory context? I mean, had Parliament intended building to have this rather limited meaning, wouldn't it have spelt it out much more clearly than it has?
It's not that I am contending for a limited meaning of building. I wouldn't accept that as a characterisation. But your Lordship's observation is, isn't this a rather surprising analysis, given that there are no other signposts? And I accept there are no other signposts, but one has to read this legislation very, very carefully.
So I'm rather puzzled, Mr. Peacock. On the one hand, you accept explicitly that building is an ordinary English word, which would imply that we can simply derive its meaning from the dictionary. You also have just told us that you're not contending for any limited meaning. So once we establish that it's a dictionary word, and you tell us that it's not, doesn't have any limited meaning, what on earth is wrong with what the First-tier Tribunal has done, which is to consider the characteristics and functions of the facilities and say, these are buildings?
What I say is the error made by the first tier is what the upper tribunal found to be errors in this regard. I was going to come to that. But the answer to my Lordship's question is that it is a failure to give proper effect to the very carefully crafted and structured statutory provisions here that clearly intend to subdivide structures into those that are merely structures and those that are structures and buildings. My loan friend was rather sniffy about my aphorism that buildings are structures but not all structures are buildings, but that encapsulate what Parliament has decided.
So although you, paragraph 104, you're summarised as saying the term building is an ordinary English word, you're not actually saying that, are you? You're saying which must be defined within its particular context and against a relevant statutory background, which I think must mean something other than an ordinary English word.
Well, that whole sentence has to be read.
Yes.
That was my case below.
Yeah.
It's an ordinary English word which must be defined within its context and against the relevant statutory background here. Just in case it becomes relevant, in relation to a number of the facilities, the first tier had found as a fact that the purpose of the facility was not to provide shelter, shelter was only incidental. I'll just give you the references, it's paragraphs 43, 47, 52 and 55. Equally, the first tier had found as a fact that most, although not all, of these facilities could be seen or thought of as a concrete box or monolith, which is the word the witness with radiation, chemical hazard, containment functions, or seismic functions. And that's paragraphs 41, 44, 50, subparagraphs 1 and 2. Criticisms.
Sorry, there seems to be some suggestion there's some magic in the word monolith. Somehow, just because you can describe something as a monolith, ergo, it's not a building. Why so?
Lord, that was not the case below. Monolith was the word the witness used.
One might say a monolith is a specific species of building.
Or structure. What the first tier, they mention the word monolith, but then they describe not all of the facilities I accept, but most of them as being concrete boxes or concrete cubes.
Well, concrete boxes used to be a common term of abuse for a certain style of architecture. Architecture of buildings.
Yes.
I mean, monolith was never really quite the right word, even as a metaphor, I don't think. I mean, I suppose I know what the witness was getting at. A monolith just means a single piece of stone. And even Stonehenge, the uprights.
It's a series of monoliths.
It's a series of monoliths.
It's a structure, but it's not a building.
Not a...
Like my own friend, I'm not going to be tempted into debating.
No, I think it's
Stonehenge or Colosseum or
an amusing parlour game.
But let's then turn to see what the upper tribunal said. Beginning at 117, this is tab 12. Page 176, discussion having set out the submissions of the parties at 113 to 116, and then it's 117 that begins the analysis. So just looking at what the upper tribunal say, 117 must be, section 21 must be construed purposefully in its context and applied to the facts viewed realistically. We accept that. 118 is harking back to the purpose of these provisions and drawing the line in the sand. 119 makes the Lord's point about sands shifting and the purpose as seen through the words of Mr. Dorrell. Then 120, turning to the meaning of building in section 21, we can see the allure of simply giving the word its natural or everyday meaning. The first tier, they record accurately, accepted the word was to be given a meaning consistent with its ordinary everyday usage. But they say rightly in our submission 121, the essential limitation of that approach is that in the context of sections 21 to 23, it begs a critical question. The question is, to what extent does the everyday meaning of building depend on the appearance or characteristics on the one hand, and to what extent on purpose or function on the other? And then there was a little debate below about Edwards and Bairstow challenges. And they record Lord Justice Nugee in this court in Devon Waste correctly saying that whether a word in the statute has its ordinary meaning or some special meaning is a question of construction of the statute and hence a question of law. So we say that's right. And then 123, they say the term ordinary meaning is itself lacking precision, and they point to the debate in this court in SSE about the meaning of tunnel and aqueduct. And what her ladyship had to say there at paragraph 39, and here they're talking about the terms in list B, but it's equally applicable to our debate. I agree with Judge Poole's comments at 38 that some of the words used in list B have an elastic meaning. They can take on the colour of the words surrounding them. determining the scope of such a chameleon word is not simply a binary choice between the widest possible dictionary meaning on the one hand and a narrowed meaning specific to a particular statutory provision derived from the noscitur and associus interpretive tool on the other. It is a more nuanced exercise than that. Many English words have a number of ordinary meanings in common usage, and the statutory meaning is not necessarily the broadest one. So we say yes to that. And 124, in this field, we do not have to decide whether building is itself a chameleon word. That's fine. The point of more general application made by Her Ladyship, with which we respectfully agree, and which we consider particularly pertinent in this case, is that many words have a number of ordinary or everyday meanings, and the statutory meaning is not necessarily the widest one. And they then go on in 125, I shan't read it, but I invite the court in due course to pay careful regards to 125 and 126, because they identify a series of difficulties that can arise, and here did arise, from usage, looking to the ordinary everyday usage. And although the second sentence in 125 doesn't begin with the word first, one might just write that in the margin because they give three reasons. And the first one begins, it assumes. Now you can see they're giving reasons because the next sentence begins second, and then the two sentences after that begins third. That's page 178 of the bundle, 125, third line, is their first reason. So 125, they identify risks. 126, they say that First-tier unfortunately failed to avoid these risks. We agree with that. 127, they say rightly that the First-tier was right to decide that the characteristics and functions of the asset are relevant. But they then identify errors. And in 128, the context in which sections 21 to 23 were enacted is described above. So that's harking back to the point that I had made in the First-tier and in the upper tribunal, that you're dividing between buildings and structures. We agree with Mr. Peacock that it follows from the way in which the provisions interact that there is a difference between a building and a structure, such that not every structure is necessarily a building. That is made clear by section 22, subsection 3. So structure means a fixed structure of any kind other than a building. This has the result that most of the leading authorities do not offer direct guidance because they discuss the difference between plant and a building or structure. That's the common law cases. So it is necessary to consider what would make a particular structure a building within section 21. What the upper tribunal then go on to say, well, there's a spectrum of everyday meanings as possible, and they identify 4 of them. In his skeleton argument and in his submissions today, my own friend in effect plumps for the first one, anything which has 4 walls and a roof.
That's absolutely wrong, because it's fundamental to his case that function is relevant, as the FTT says, and that the FTT took function into account. It's no part of Mr. Bremner's case that function is irrelevant.
Well, that was his case below, and in his skeleton argument in this court, he plumps, in effect, for this first reading. Now,
I think the transcript will show that he accepted that function is relevant. Certainly, the FTT accepted that function is relevant.
And I agree, it's part of my case that function is relevant.
And yet you're saying that the FTT was wrong. I still fail to understand how you say that they were right to say that function was relevant and to take function into account in their analysis, and yet still erred in law. That is a mystery to me at the moment.
What I am saying, my lord, is what the upper tribunal here said. One needs to read it in sequence, and of course carefully. But they start in 128 with identifying the statutory context. In 129, they rightly recognise that a spectrum of everyday meanings is possible. And then in 130, they say, the context and purpose of section 21, that's harking back to statutory context and statutory purpose supports a construction of building in which function is particularly important and in which appearance or physical characteristics should not be the primary determinant of the line in the sand, which sections 21 to 23 were intended to draw. And we say that is right, that is what you get from the statutory context. Because, to repeat, you've heard this from me no doubt too many times, we are directed to draw a distinction between an asset that passes the common law test, that is a structure that may not need to rely on this C to be entitled to allowances, and an asset that passes the common law test, which is a building which is barred absent this C. So the upper tribunal are right to say that when one might look at two assets that may have similar appearances, it's the function of the asset that is particularly important, and appearance or physical characteristics should not be the primary determinant. And I say, as a statement of the law as to the meaning of building in this context, that is right. Having decided that, they then go on to say in 131 that they think the first tier erred in several interrelated respects, and we agree and endorse that reasoning. And of course it's important, Lord Justice Arnold's point, to bear in mind, the upper tribunal are not saying these are structures and not buildings. They are saying that the first tier was wrong to conclude that they are buildings. What they do, quite rightly, is to remit this case, as regards this issue, back to the first tier for it to reconsider the position, because the judge here, Judge Cannon, had the benefit of the evidence and the site visit and the witnesses and the photos and the plans. So they're not saying these are definitely structures and could not be buildings.
And given that questions of weight are for the FTT, how are they supposed to, as it were, redo the exercise? Directing themselves that function is particularly important and not the primary determinant, when that wasn't anyway the basis on which they'd decided it in the first place.
Well, that's identifying that that's the error the upper tribunal think that the first tier made.
Mm.
But the upper tribunal is not in a position itself to determine the status of these assets.
Well, I can see the logic of, yes, of remitting if there's no, if it's not a case where on the facts there's only one possible conclusion to be drawn.
And just pointing out that my learned friend did faintly advance that in both building
Yeah,
and
I know.
common law.
Yes, and well, one of the things we may have to consider, but in a situation where there isn't only one fairly right answer, and assuming it to be such a case, then remitter is usually the right thing to do, although not necessarily, because under the 2007 Act, the upper tribunal can embark on the exercise itself.
It could do.
It has its own ability to draw factual conclusions, as Lord Carnell's pointed out in Pendragon.
And as your lordship discussed with my lady in the De Gorse case.
Indeed, yeah.
But whether it decides to remit or remake is a discretion in effect for the upper tribunal, not challenged here.
Mm.
So I got my ground of appeal point, but more fundamentally,
Yes,
as a matter of principle, what the upper tribunal are doing here is saying that they believe the first tier erred in its construction of the building in context. Therefore, its conclusion that these were buildings is unsafe. But the upper tribunal is not saying that they are definitely structures and not buildings. And all
So I'm still not clear what your answer is to my lord's question, because we imagine this going back to the FTT. The FTT sees that they were right to take into account characteristics of the assets and the functions of the assets. So why don't they just go through the same exercise and reach the same conclusion?
What the upper tribunal is directing them to do is to redo that exercise with the benefit of the upper tribunal's observations as to the legal test. And
how does it lead to a different conclusion? That's the question.
With respect, my lord, that's a matter for the first-tier tribunal. I accept, both candidly and logically, that this could go back and the first-tier judge could arrive at the same conclusion. The upper tribunal's point is he has erred in law in the test that he has applied, so putting it slightly crudely, he has to have another go.
But when one gets down to the nitty-gritty, what is the FTT supposed to be doing differently next time? The furthest one can get out of it is that they should have given more weight to the functions. That seems to be the gravamen of it. But then, as my lord said to you, the question of weight was a matter for the FTT to start with.
But my lord, one is confusing a world in which they have made an error of law and they're directed to correct it, when in redoing that exercise, matters of weight are for the first tier unless they err again. But one can't say just because weight was a matter for them, they can't have made an error of law. There are two different lines of logic there, and one needs to keep them separate. So, yes, weight was a matter for them, but if they erred in law, I'm entitled to say, well, it must go back, as the upper tribunal said. And it is a matter of weight, and then if I win or lose, then I may or may not have an appeal, or my learned friend may not have. But one needs to keep separate the threshold question, did they err in law, which the upper tribunal said yes, with the exercise the first tier would do again with the benefit of the upper tribunal's guidance. It's not just a paragraph 130. I haven't read it out, so I thought not using the court's time, but we do stand by each of the three errors that are said in the upper tribunal paragraph 131 to have been made by the first tier. And they say those are criticisms of the first tier's reasoning that the upper tribunal say, and we agree, reveal errors of law. I noticed the time. I think very nearly finished building, but if I might reflect overnight on anything else that I might need to come back on. But I would think that we would still be on good time for me to move either very quickly or immediately tomorrow on to my learned friend's ground 2, which is the common law question.
Very well. So we'll rise now. Thank you very much.